Reed again with Charlie Barnhart and Associates, and I'm here with David Serepca, who's an attorney in the industry. He is here to discuss some of the trends that he's seeing in terms of contracts, in terms and conditions, and that type of thing. You've discussed the concept of risk protection overkill, which you've identified as an area that you think is something the OEM should be looking at. What is that exactly, and how does that affect the OEM?
So Jennifer, in the area of liability protection and indemnification, I see that OEMs are extremely aggressive in trying to hold the contract manufacturer liable for any and all losses that's over and above what they would be entitled to at law. And to the extent that there's a complete attempt to eliminate any risk associated with the relationship and thereby overly protect themselves to the extent that they create a hostile environment for the relationship. And so what they give up by doing that is that there are CMs that won't sign those agreements and won't sign up for them. And I think that they're hurting themselves to the extent that they're missing out on some good providers that could be providing those services to them with reasonable terms. Or they're going forward without contracts on a PO basis in many instances, where they're subject to standard legal limitations on liability that are applicable in the PO relationship, but without getting the contractual benefits of key controls over the relationship that don't exist in the PO-based
So in effect,
relationship.
They're increasing their risk rather than reducing their risk by insisting on these overly extreme contract terms. Can you give me some examples of terms where that end up hurting the OEM? Because you might think that an OEM would just push his advantage as far as they can, and why shouldn't they? If they have some leverage, if they're the stronger party in the negotiation process, why shouldn't they just try to keep pressing their advantage?
Right, and I think that's a fair question. You know, I think that the reason is because for two reasons. One is because they're creating a hostile relationship, and if it starts out in hostility and over aggressiveness, it's like any relationship that lacks a minimal assumption of risk and lacks trust and respect. It's doomed to failure. We've seen that a lot, and I think that contract manufacturers truly want long-term relationships, and that's where they do the best and the customer does the best, in my experience. So it's short-sighted. Additionally, they are hurting themselves to the extent that they have insurance protection and they have protection in their own contracts on their sales side with their distribution agreements and their customer contracts that protect them. So it's an overkill, as I call it, because they just don't need it. Specific examples would include overly aggressive indemnification provisions that try to hold the CM responsible for certain IP problems, as well as just minimal breach of contract indemnification for all liabilities that might flow from a breach.
Okay.
We see that is a deal killer in many instances with a CM. So I think that if attitudes at the OEM level change to the extent that they realize that they don't need to be as aggressive to get a contract in place with the proper balances that give them the benefits of the agreements in those key controls, and that they're covered in other ways organizationally and institutionally and structurally in the supply chain, that they would be much, much better off.
Okay, very interesting. Thank you very much.
Thank you, Jennifer.